Hey everyone. Not some of you guys not knowing who Daystar Peterson is. It's Tory Lanez. It's this guy up here on the screen. Let's get into it.
Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello everyone. It is Pam Esquire, also known as the Law Intellect. Welcome to the channel. If you have been here before, welcome back. If you will be so kind, many of you have already hit the like button and consider subscribing to the channel. We are here to talk about Daystar Peterson, aka Tory Lanez. It is funny that you said I had to Google him. Well, that's how I felt when I actually went to California a few years ago to cover this trial. And my commentary was just, I don't know if people thought I was in there making it up. I don't know what people thought because there were literally people that were commentating on this case in a way that was not adequately reporting on this case. All right. And because of that, people were confused, or maybe it was plausible. They wanted to be confused about the real facts of this case. In fact, partly because of this case, on Monday, you have Milagro Grams, who is going to be on trial because of some allegations that have been filed against her by Megan Pete. And so, yeah, I have to look today too, because I think they had some type of conference. But the last time I checked, they were going to trial on Monday. When I tell you, I did not know what I was getting into when I got into it. People that are fans of these celebrities are a different type of people. As you saw the other day, I just talked about the situation with Milagro and um Meg the Stallion or Megan Pete, and people automatically, you're lying, you're lying. I don't understand the wiring of the brain of some people. I just don't, I just can't wrap my mind around it. So when Daystar Peterson or Tory Lanez appealed this case, one of the things I said was I was there. You guys are regurgitating the same exact information that was already known. When people came out, oh man, unite the people did they big one on this appellate argument. I'm like, were you guys watching the same arguments as, or maybe they just thought you can go to the Court of Appeals and re-argue everything. One of the things that I said, which I know when people don't like me, they don't care about what I say, right? So it doesn't matter. Sometimes I'm actually saying things that are helpful. I said, sir, if you are alleging that you did not do this and this was a wrongful conviction, then you need to go find some new evidence, or either you find some new evidence, perhaps the prosecutors, you can, if you can prove that they kept some exculpatory or favorable evidence away from you, you have to find something. You don't go to the Court of Appeals basically re-arguing what you've been arguing dang near the whole time, or to say evidence is new that really wasn't new, but you just decided not to utilize it, aka the bodyguards and all of that. I was there. I was there. I was there on a daily basis. I was there for 2 weeks. In fact, I only was supposed to be there for a week, and there was a snowstorm in Michigan, and I couldn't come back home, and I spent that Christmas down there because of it. So it's very, very memorable. And people were really acting like I was making this stuff up. So what I have for you today, intellects, is an actual opinion from the Court of Appeals over there in California, and they lay out some of the facts. They lay out the intro on how we got here, because at this point it's been so many years, I think people have forgotten. Okay. So we're going to go over that. I didn't just come on to say he lost. I'm going to come over and tell you why the Court of Appeals made the decision that they made. Of course, if he wants to, be froggy about it and go even further and go to the state Supreme Court, I guess he can try that as well if they agree to hear it. But I don't know. I'm not going to say never, because there are a couple of other celebrities who have fans that it doesn't matter what they've done, they willing to windmill. Some people are obviously willing to ruin their lives. I don't get it. I don't get it. But I do wrongful I literally was talking about it in the hallway. I'm like, this is one of the areas that I actually have some familiarity with. Now, come to me about tax law, it's a no. Come to me about immigration, it's a no. Although I think I'm going to learn it. But as of today, it's a no. So, but that is actually an area of law of which I am quite try to stay up on, because it's something that I actually do. And I was like, listen, this is the type of stuff that you should be focusing on. Not we gonna get you getting the public to windmill and say he ain't do it. It was Kelsey. They lied. Everybody lied. You lied. You lied. You lied. You lied. That's not helping that man. And people weren't picking up what I was putting down because they was too busy, pretty, mad or whatever. Because I wasn't reporting it the way that they wanted me to report it. But I remember being in that courtroom, and we about to pull up this document in a minute. I'm just giving people a few minutes to come in. I remember being in that courtroom and seeing Megan on the stand. And people can say they don't like her. They can say she's a liar. They can say all of that. But what I will say is her testimony was persuasive. And I came back and I said it. Of course, the people that don't like her was saying she got on that stand and she lied, lied, lied. They had a whole different rendition, because you see and you hear what you want to hear when you come in with the bias. So you have confirmation bias. You trying to just go in and confirm what you already wanted it to be. I came in there and didn't even know who these people were for real. So I had to ask my son, who is Tory Lanez? Where did he come from? No clue. But she was on the stand, and they put up text messages, not text messages, social media posts, websites, hate pages of people that were literally tormenting this lady. When I say I remember distinctly one of the messages was, I wish he would not have shot you in your foot, but would have shot you in your. I wish you would have died. When I say nasty, that alone, the right thing for this man to do, instead of all of this windmilling out here and having all these disrespectful people in the chat, listen, I don't agree with the verdict. I'm gonna fight, and I plan on fighting, but y'all don't harass her. Don't come for her. Let her live in peace. Things are gonna happen the way they're supposed to happen, because they were preaching all in the hallway. So this was your time to say all things work together. So I'm just gonna see how God does this. But the opposite happened where it was just getting worse and worse and worse even after the verdict. When she had already went through all of this before the verdict, because of all the people that did not care that this lady saying she was harmed and didn't care about what evidence was used in court. Didn't care. Just cared that this was their fave. That was it. That's all they cared about. And this could have went in such a better way, of which but you guys are gonna see. You're gonna see, even when he was on bond, he went back and had some bond issues for not abiding by his bond conditions. This is not just somebody who was just railroaded. There are people out here that are literally railroaded, framed, bullets planted, officers lying on the stand, prosecutors withholding exculpatory evidence, literally people doing decades for this. This was not that type of a case. And that's what was pissing me off about this case and how people were windmilling about this case. Thank you, Gotta Love Jones, for the super chat. I appreciate that. LK, thank you for the super sticker. Mega Boo Plan said, Pam, you're so dope and an inspiration. I'm taking the LSAT soon. Love your content. Much love from the 248. Well, you got my email. You can always hit me up. And I know you're going to be fine. And I'm going to welcome you in advance to one of the greatest professions on this earth. Hey, sis. Hey, sis. Hey, queen. Hey, Elite Leo. You said Sunstar is as unhinged as his fans and his son. So Sunstar came out so calm. I told you, I talked to him in the hallway. He was talking about scriptures. He talked about his missionary work. He really was so calm. And then when that sentencing came down, was it the sentencing? No, I think it was the verdict. It was one of them. I was there for both. I had to fly back down, I think, for the sentencing. When that verdict or sentencing, I can't remember which one, but he yelled at the prosecutors. He called. When I tell you that people profess the peace of God that surpasses all understanding until you really gotta show it. It's easy to say, but it's a little bit different for you to apply. I was shocked. I'm not gonna lie. Then he went outside in front of the news people. This had to be the verdict then. I think it was the verdict. I don't know. I can't remember. Anyway, it was one of them hearings. But I know he went in front of the news people and he was talking about Rock Nation and all of that. And I'm like, why y'all blaming Rock Nation? Ain't nobody from Rock Nation testify. Nobody even said that he even got a contract from. You didn't have one person get on this stand and say, we offered this man a contract and he turned us down. To even make inferences. You can't even make inferences unless there's something to make inferences from. So you don't always have direct evidence of certain situations. You may have circumstantial evidence, but it has to come from someplace. It can't just be out the sky. And it was so out the sky when people was talking about Rock Nation. It was just random. Everything was so random. I just this thing here. Catherine McConico, thank you for the super chat. You said, hello, Pam. Love your channel on the truth and nothing but the truth. Kudos to you. I try. I really try. And on this case, they really were testing my ability to be to just remain like this, because I had so many people that were fighting me because I was reporting what was in the courtroom. They were really upset because I was reporting what was in the court. What y'all want me to say? I don't understand. So Ray Ray said it wasn't something he had a diversion. So in theory, I think it was brought up about carrying a GUN, but he had a diversion program, so it shouldn't be on his record. That's the point of diversion. They give you certain criterias. Once you complete those criterias, they dismiss it. So you're not really convicted. So no, it's not probation because you're not convicted. He was just they allow you to go into a program. So basically your case is stayed or on hold. And then if you successfully complete it, you go in, they'll drop it. With a lot of those different programs. And I believe he had a program similar to that down in Florida or something. So no, from my understanding, I don't believe he was on any type of probation. I think he had a diversion program of which he had completed. But Rhea said, I hope Meg gets enough evidence from the Milagro lawsuit to also sue that evil receding hairline leprechaun too. He may be called to testify. That trial, honestly, it's taking a lot in me not to just bite the bullet and go. But I'm like, I'll be so behind because I just came back from out of town. Then I go back out of town a week after that. So I was like, man, I'll be doing too much. But I don't know if I can. It's in federal court, so it won't be streamed. And I just don't know if I could trust all the commentary that will come out of it, to be honest. But I just don't know if I could swing it at this point. Whack 100 claiming he had a video of the incident that proved Tory's innocence made the harassment of Meg worse. Well, if he had the video, why didn't he turn it over? So did anybody see this video? Did they subpoena this video? Because if I was Tory's defense team and somebody came to me and told me that, honey, you're getting subpoenaed immediately. I need you under oath to say the same thing, and I need you to produce this video you're alleging if it's going to exonerate my client. Oh, he was calling it probate. He may have been. That came up in court too because they felt like it shouldn't have been raised at all. But this is the opinion. The Court of Appeals of the State of California, Second Appellate District, the people versus Daystar Peterson. Let's get into these facts, okay? Because yeah, I think people just done forgot. Facts and procedural background. On July 12, 2020, Pete went to a gathering at Kylie Jenner's house. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend and personal assistant, Kelsey Harris, and Peterson got in an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationships among Pete Harris and Peterson. Pete asked to be let out of the SUV. Pete got out and started walking away. She heard Peterson say, dance, BITCH. Pete turned her head a little bit and saw Peterson pointing a GUN at her. She froze. Pete heard shots. She looked down at her feet and saw all the blood. Now this is really a snippet because there was a lot that happened in the car. They left the house. Meg left the shoe at Kylie's house. Meg came back to get the shoe. That's why you had EJ who came and testified as well. They get back in the car. The argument was allegedly Tory decided to let them know he was sleeping with both of them. They get on Sunset Boulevard. She gets out the car. Meg gets out the car allegedly on Sunset Boulevard, starts walking in her bikini down the street. Tory is behind her, telling her to get in the car. They get back in the car. Somehow they end up pulled over in some kind of roadway or alleyway behind the house of Sean Kelly, who testified. So it was a lot that kind of happened in between. And even what I'm saying is a summary, but the court said we ain't got time for all of that. So we just gonna pull out. Said You shot, told me to dance, bitch. Pete turned her head a little bit and saw Peterson pointing a gun at her feet. She froze. She heard shots. She looked down at her feet and she saw all the blood. Pete dropped to the ground, crawled into the driveway. Pete felt pain in both her feet. After that, it got blurry. So all the quotes you see are from the transcript from when she testified. So when you see the quotes on this document, let me big it up a little bit. Those are direct quotes from her. So the court is pulling out quotes from the transcript. Pete got back into the SUV. They heard police sirens, and Peterson told Pete and Harris, quote, "Please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each," end quote. So this is what the testimony was. This is at 4:27 a.m. Harris sent a text to Justin Edison, who handled Pete's security. The text said, "Help, Tory shot Meg." This is what you would call an excited utterance, because who just types that randomly unless you're in the middle and your adrenaline is high and you don't know what to do? So they put Peterson is a rap artist, performed as Tory Lanez. The record reflects friends also called him Tory. So the court did a footnote. All right. Police stopped the SUV. They asked everyone to get out. Pete told the police she stepped on glass. She didn't tell them she'd been shot. When asked at trial why she told the police she stepped on glass, Pete referred to the then recent murder of George Floyd. Pete testified she didn't, quote, know if they're going to shoot first and ask questions later, end quote, and she didn't, quote, feel safe with the police officer. So she's saying, so she was asked about why she said that she stepped on glass when she actually got shot. That was an issue raised at the trial. So that is not new. It was nothing new. There was actually a surgeon who performed the surgery who said they were bullet fragments. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in the slide lock position, meaning all the rounds had been fired from the magazine. It was warm to the touch, even though it was cold outside at that hour of the morning. Officers also found a bloody towel in the back seat. The officers took Peterson, Harris, and Smith into custody. At the station, officers checked the hands of all three for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would not be surprised if Harris tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken by Smith. So the way it was laid out at the trial, Kelsey was in the back seat. Meg had her bleeding leg on Kelsey. She had her leg up on her. So she was within that close vicinity of her anyway when it came to the gunshot residue. People like the gunshot residue. That came up in the trial, as you guys see. This was not new information that was not presented that a jury did not see. The jury knew all. The jury knew that she had gunshot residue on her. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she'd been shot. She later explained, quote, in the Black community, it's not really acceptable to be cooperating with police officers, end quote. Pete also said that when a woman accuses a man of something, quote, people have a hard time believing you, end quote. She added, quote, this whole situation in the industry like a big boys club. Like I'm telling all of y'all's friends and not everybody about to hate me, end quote. So she basically said she put in the whole women aren't believed is one of the reasons why she did not want to. She didn't immediately tell on Tory. And also that she's in a music industry that's predominantly male and that she feels like this could ruin her career. Everybody don't like her. I'm just saying, she's had a struggle since this happened. She has definitely struggled since this trial. Around 9:05 the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harris told Peterson that Pete was still in the hospital and she was waiting outside. I want you all to listen to this call. This is the evidence that the jury heard. Peterson said, quote, I know she probably never ever gonna ever talk to me ever again. But bruh, I just want you to know, bruh, Ninja, I was just so effing drunk. I never do some ish like that, bruh. You know, regardless, that's not gonna make anything right. And that's not gonna make my actions right, bro. But I'm just deeply sorry, bruh. So, like, I feel crazy, bruh, but made a mistake. Like, what happened already, bruh. I can't take it back, bruh. I'm just telling y'all, I'm sorry, bruh. How y'all interpreting that? Huh? How do you guys interpret this call? I'm seeing people twist it in different ways. I'm like, how can you not think that a jury can make an inference that he was confessing, basically? Said he was drunk. No, she's not gonna talk to him again. He's sorry. What you sorry for if you didn't do anything? Huh? I think he tried to I think they tried to spin it like he was sorry the whole thing happened or something like that. But he wasn't confessing that he was the one that did it. Hmm? You told on yourself. Listen, bruh. I don't understand how people want to stand behind the lie. I don't. They pull up stuff. They're mad at the reporters. You know, they're mad at anybody that say anything different. And Meg got tired of that and she sued you. I mean, you cannot think that somebody is going to live in a constant state of torment. And it may or may not have consequences to it. People swear he talking about cheating. How you cheating if everybody's single? Huh? That man had a whole baby mama that was there who talked about she was about to marry. They were going to get married. She said that was her fiance. And I think they got married when he was in jail, right before he went to jail or when he went to jail. But I don't know if they married anymore. But he had a whole baby mama that was there on a record. If you free him, then you guys are gonna be on the news like them guys in Louisiana at this point. I'm just saying. Let's go on. At 8:59 p.m. that evening, Peterson texted Pete. The text said, so this is Tory texting Meg. Meg, I know you probably never gonna talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart. And I was just too drunk. Nonetheless, ish should have never happened, and I can't change what I did. I just feel horrible because I generally just got too drunk. I love you and I hope you're okay. So, all of this is because you think Meg was that mad because she found out that he was sleeping, or he told Kelsey that them two were sleeping together. If anything, it probably would have bothered Kelsey more than it would have Meg, because Meg knew about Kelsey. Kelsey testified that Meg prompted the relationship or whatever situationship that Tory and Kelsey had at one point. Prompted it. Then they messed around a couple of times. And then apparently that was that. And then during the pandemic, Meg and Tory got a little close, got a little cozy and close. Well, that's what they say. They say Tory not talking about the day he dated from. That's the argument. They like, oh my God, it's clear he was talking about him telling that they were dating, that he was sleeping with both of them, or that he started sleeping with Meg. Okay, guys. Thank you so much, clutching my pearls for the super chat. I appreciate that. You said Kelsey was livid and rightfully so. They did that girl dirty. It was foul. It sounded real foul. It did. DC Lively said, why are friends sleeping with the same dude? This some soap opera-ish mess. Why do a lot of people do what they do, y'all? I don't know. Okay, so there go that. You're probably never gonna talk to me again. Okay, so there's the text. Peterson sent Pete other text messages just apologizing. Pete had bullet fragments in both of her feet. I repeat. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the shooting, Pete told police who had shot her. Pete testified she'd had changed of heart because Peterson, quote, had tried to start getting ahead of the story online. He put it on a bunch of different narratives about what happened. So basically, if your mouth would have been closed, she probably would have just chalked this up to the game. But then she felt like she had to come out because you was out here talking so much. That's what she testified to. Clutching my pearl said, wow, I didn't know he texted Meg more than one. That's why I felt inclined to just read the opinion, because I know they're going to pull out certain quotes before they get to why they affirmed the conviction. About 4 days after the shooting, Pete told police who had shot her. She testified she had to change her heart. I read that already. DNA testing of the Luger revealed a profile of at least 4 people. So I want y'all to pay attention to this part, because this was another thing that I saw all over about the DNA. I said there were experts. We already know about touch DNA. They talked about DNA till you wanted to vomit. Okay, how you can just touch something and you leave little particle unless you got gloves on. How it's a mixture. How sometimes it's not enough. How me sitting right here, if I just touch this right here, it was demonstrations, it was hypotheticals, it was all type of different ways and fashions and stories and for you to understand the DNA in this case. So for people to go online and talk about the DNA, I'm like, they talked about it a whole lot in this trial. So anyway, DNA testing of the Luger revealed a profile of at least 4 people. Peterson could not be excluded or included. So it wasn't enough to exclude him or include him. So it was, his contribution was inconclusive. DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them. So the actual magazine, whoever was loading it, it had 4 people, where he was eliminated from that. No usable fingerprints were found on the gun or the magazine. So there were no fingerprints that were on the gun that they could use. So it's probably smudged, smeared, perhaps wiped off. Anything could have happened as to why there were no fingerprints that were on the gun. In response to the prosecutor's questions at trial, Pete testified she was, quote, having a really difficult time sitting up there and trying to comfortably tell her story, end quote. Apparently referring to spectators in the courtroom. Pete said, quote, a group of people had been continuously spreading misinformation to make her look like a bad person. Mm-hmm. According to the bodyguard, this is allegedly. Tori and Meg used to scrap all the time. The toxicity was cute to them, and then it went way too far. Ain't nothing cute about you pulling no GUN out on me. Ain't nothing cute about that. She clearly liked him, doesn't excuse nothing, but there was a mutual interest. I mean, we know they liked each other. They were messing with each other. I would suppose they liked each other enough. Like something about each other. Okay, so let's get to the charges, the trial, and the verdict. So the people charged Peterson with an assault with a semi-automatic firearm on Pete, which was count 1, having a concealed firearm not registered to him in a vehicle, count 2, and discharge of a firearm with gross negligence, count 3. In count 1, the people allege Peterson personally used a firearm. In counts 1 and 3, the people allege Peterson personally inflicted great bodily harm on Pete. The people also allege aggravated factors under the California Rules of Court. The case went to trial in December 2022. Among other witnesses, the defense called Sean Kelly. So this is the neighbor. And the defense, you guys hear this? Among other witnesses, the defense, that means Tory's team, called Sean Kelly. Kelly testified he lived near Nichols Canyon. In July 2020, Kelly was asleep. It's a footnote. Okay, wait a minute. About 2 weeks into the trial, near the end of the people's case, the prosecution moved to add 2 more felony counts to the information for dissuading 2 witnesses, Pete and Harris, under Penal Code 136.1. The court denied the motion. So they were trying to amend it and add 2 more counts about, I guess, but the court denied that. So they couldn't add those charges. Counsel didn't ask Kelly about a precise date, referring only to, quote, an incident that took place on July of 2020. So I guess they wouldn't let us know why they using July 2020 instead of the exact date of the incident. In July 2020, Kelly was asleep. He was awakened by lots of shouting and voices. He looked through his window and saw, quote, 2 girls arguing, end quote. Then they, quote, started fighting. They were pulling their hair and hitting each other. It was quite violent. Now, what I will say is both of them testified as if there was no fight. Sean Kelly did say that they were fighting, that the 2 girls that he saw were fighting. So that was a conflict that was kind of like that I recall from that trial. A tall man got out of the driver's side of the car and got involved in the fighting. So that was supposed to be the bodyguard. One of the girls went to the car. Kelly then heard what at first he thought were fireworks. He saw a muzzle flash. At about the same time, a smaller gentleman got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. The muzzle flash was near the girls. So he testified that the muzzle was near the girls, right? Kelly did not hear anyone say dance, B-I-T-C-H. Although both defense counsel's questions and Kelly's answers were unclear, Kelly seemed to say the girl who was the aggressor went to the car and he saw the muzzle, quote, flashing coming from her hand. Kelly then said, quote, the flashes came from the shorter man. So at first, it kind of felt like maybe, I don't know, but he said it was a mixed. Obviously, he got called to the stand, I would assume, because at some point, maybe all of the questioning was not clear when they interviewed him, but it seemed that he would testify that it wasn't Tory who shot, but maybe it was a girl. But then he got on the stand. I remember the moment. He said the flashes came from the shorter man. He kept calling Tory the shorter guy, the small guy. That's what he was like referencing him as. And I remember people, when I reported that, people said it didn't happen. I'm like, he did say that. He was like, the flashes came from the shorter man. Then they say Kelly testified, I believe I saw the girl shoot first. They were both shooting. Kelly never saw a gun. He called 911. On cross-examination, Kelly admitted, so cross-examination is by the prosecutors because this is the defense. So on cross-examination, Kelly admitted he told investigators that, quote, the short guy came out of the car, end quote, and then, quote, he shot the girl. So the defense called him because I guess they thought he was just going to point to one of the girls doing it. But he told the prosecutor allegedly that it was the short guy who did it all along. Now, in the beginning of the conversation of the direct examination, it sounds like a mixture. You don't know. First it's her, then it's him, then it's her, then it's him. But when it came to cross-examination, he admitted that he told the investigators that he got out of the car and then shot him. The short guy came out of the car and then shot the girl. The girl then fell into the road and started bleeding. When asked what was he saying at the time, Kelly replied, and he had this accent. I don't know where he's from, Australia or something, but Sean Kelly had a thick accent. And he was like, so you'll kind of, hey, 504, I ain't seen you in a minute, sis. Good to see you. So when you hear the words that he uses to describe it, that's why. Like, he's like, it was torrent. It was, I mean, it was just. So he says, they asked him, what did you hear? Like, what did you hear when everything, whatever. When asked what was he saying at the time, Kelly replied, a torrent of abuse. It was all just N-words. And F, mother effer. And Kelly also admitted he never mentioned, quote, a girl involved in the shooting to the 911 operator, nor did he mention a female shooter to the responding officer. So on cross, what the prosecutor did was they took their time to not let it be ambiguous as to whether it was a guy or a girl, of which he believes the flash, because he didn't see a gun, but the muzzle flash came from, and they pinpointed it from prior interview that he had. Now, this is where Tory's dad, I guess, got pissed off because he alleged that Sean Kelly, after talking to the prosecutor, his testimony wasn't the same as when he talked to their investigator. So at the end of the day, you got information that they're saying the short guy did it. You got information that maybe he at some point said that it was one of the girls who did it. And the jury has to weigh all the evidence. So you got Tory apologizing. I don't think we saw any text or anything of Kelsey apologizing for anything. You have the text, you have the audio, you have then you have this man saying that those jurors is being the trier of fact. They have to weigh the evidence and see if he was guilty beyond a reasonable doubt. And people were mad at their decision. They wanted them to pick evidence as it's reasonable doubt all over the place. They can take part of your testimony and believe it, or they could take all of your testimony and believe it, or they could take none of your testimony and believe it. That's what a jury does. They do not have to take everything that you say as if it's the truth. You get caught up in cross-examination for impeachment. Sometimes it's the jury instruction. You can discredit all their testimony. If you think they lie once, you can think they'll lie again. But it's up to the trier of fact to do. And I think people just felt like because it was some iffy moments, and it was. I'm not going to say that it's not. And if it was hammered in differently, I'd have did it differently. If it was hammered in differently, it probably would have ended differently. But it wasn't. And this is what the facts the jury was given. And that's what it is. So I see why they came up with what they came up with. Thank you, Brother Brown, for the super sticker. I appreciate that. People put in countless appeals even knowing they're guilty. Well, it's powerful, of course. Some people want to try to find a way to do less time, you know? It's kind of powerful, of course. And some people put in appeals because they really didn't do it, you know? All right, let's go on. Peterson chose not to testify. The jury convicted Peterson on all 3 counts and found the firearm and great bodily injury allegations true. Peterson, represented by new counsel. So this is when, after he lost the trial, he hired Jose Baez. I guess they felt like he can get Casey Anthony off. He can get anybody out. I didn't even understand the point. I'm going to be honest. It just felt like, I don't know. Peterson, represented by new counsel, filed a motion for a new trial. The court conducted a lengthy hearing on the motion over several days. The court ultimately denied the motion. The court conducted a bench trial on the factors in aggravation under the California Rules Court. The court found true aggravating factors that Peterson used a weapon in the commission of the crime and that the victim was particularly vulnerable. The court also found Peterson's conduct toward the victim after the incident to be an aggravating factor. The court listed social media posts, releasing songs with lyrics directed toward the victim, attempts to dissuade or perhaps give money to her and the other witnesses, and violating the protective order. So he got aggravating factors which contributed to this long sentence. He was not, he still was, it was the entitlement. Like, it felt like, I'm famous, nothing's gonna happen to me. That's what it was giving out here. Now look at this footnote. The trial court increased Peterson's bail several times between his arraignment in November 2020 and trial in December 2022. In August 2021, the court granted the prosecution's motion to increase bail. As a condition of bail at the new higher amount, the court ordered Peterson, quote, not to attend or appear at events where Megan P. is scheduled to appear. In April 2022, the parties again appeared before the court to discuss another motion the prosecution had filed to increase bail. The prosecutor referred to a music video where he's depicting violent imagery coupled with a lookalike in the video of Pete and her boyfriend. This apparently was a reference to a music video Pete mentioned in her testimony at trial showing Peterson chopping up horse legs. Based on the exhibits the prosecution presented, the court found Peterson in violation of both the protective order and the discovery order. As a condition of bail at the new higher amount, the court told Peterson, quote, sir, you are not to mention Pete in this case or anything about this case in any social media or any public statements, either directly or indirectly. In October 2022, the parties appeared before the court yet again on the prosecution's motion to set bail at no bail. The court denied that motion but ordered, quote, electronic monitoring house arrest, end quote, for Peterson pending trial. The record on appeal includes reporters and clerks' transcripts of the bail proceedings, but not the motions, oppositions, briefs, or exhibits filed in connection with them. But nobody remembers any of this stuff. They just don't. Not when it comes to him. The court stated, I think this is a very significant aggravating factor in this case. The court added there were 2 times that he violated the protective order where the court had to step in and raise his bail. The court found not true the prosecution's allegation that the crime involved a high degree of cruelty, viciousness, or callousness within the meaning of Rule 4.421A1. So he was winning on some of them. Like, the court wasn't just whatever the prosecution said. Some of it he was winning on. He got a little something, something. The court also found 3 mitigating factors. So factors that's favorable to him that should help him. That Peterson had no prior record or any insignificant record of criminal conduct, that he had actively participated in charitable or philanthropic causes, and that he did not pose a significant risk of reoffending in a violent manner. So the court also mitigated some of his the factors when it came to his sentencing. And when I say his philanthropic video was looked like it was produced by the people over at Netflix, they show him he's in Atlanta. Then they'll show a plane. He dropping off turkeys and whatever he doing in Atlanta. Then they'll show the dot of him flying over to the next place where he's giving a lot of stuff away. Again, unite the people. They were recipients of some of his generosity. So he did seem like, that he was a giving individual. He just seems like he might have needed little alcohol intervention or a lot of alcohol intervention. I don't know. He was drunk on that day, according to him. And some anger management, because there were some other issues that were alleged with August Alsina, and there was someone else doing it. It was just always something with this guy. So I just don't understand why people were windmilling the way they're windmilling. I mean, they are literally coming for anybody that says anything that is the opposite. Like, it's insanity to me. Before pronouncing sentence, the court heard from 7 witnesses called by Peterson. The court also listed the authors of 76 letters it had received from Peterson's supporters. A prosecutor read aloud a letter written by Pete as a victim impact statement. The prosecution asked the court to sentence Peterson to 13 years in the state prison. The court sentenced Peterson to 10 years. The court found the aggravating and mitigating circumstances were a wash. The court selected the midterm of 6 years on count 1, assault with a semi-automatic firearm. The court also chose the midterm of 4 years for the firearm enhancement. On count 2, carrying a concealed unregistered firearm in a vehicle, the court sentenced Peterson to the midterm of 2 years to be served concurrent with count 1. So it's supposed to be those 2 years are being served the same time as the first count. So it's not tacking on to the end. It's at the same time. The court stayed under section 654, the sentence on count 3, discharge of a firearm with gross negligence. As to both counts 1 and 3, the court dismissed the great bodily injury enhancement under section 1385, subdivision C2, presumably in accordance with Senate Bill number 81. So those are the basic facts. Again, you can't pour a whole trial and all the transcripts into the opinion, but those are the basic facts as to what type of evidence was there at trial. So the court says the trial court did not abuse its discretion in permitting the prosecutor to ask Pete questions directed to her inconsistent report to police and her attitude about the case and about testifying. So this was his argument. This was one of his first claims in his appeals brief. Peterson contends the trial court abused its discretion in allowing testimony and evidence concerning Pete's emotions about the incident and its aftermath. On direct examination, the prosecutor asked Pete questions about her initial statements to law enforcement and medical personnel that she'd cut her feet on glass. Of course, they're going to talk about it because they knew that was going to be what the defense was going to use. So you try to get ahead of it. You have to be the one to put out your bad facts. So it takes away the sting of it for a jury. It's like, oh, I heard that before. I heard it already. Pete responded that when a woman says a man did something to her, people have a hard time believing you. Pete says she never wanted to come forward. I didn't want to say nothing in the first place. Defense counsel objected to 9 questions along these lines. The court overruled 5 of the objections and sustained 4. So they go over on cross-examination. Defense counsel repeatedly asked Pete if she had lied. You also on CBS were asked a couple of times. So this is the Gayle King. Remember, she got on Gayle King and basically said she wasn't having a relationship with Tory, and we found out that was a lie. On cross-examination, defense counsel asked, you also on CBS were asked a couple of times if you had some type of sexual relationship with my client, correct? Yes. And you lied, correct? Yes. You lied on national TV, correct? Yes. You also lied to the prosecutors, correct? Yes. You also lied to Detective Stogner about this issue about the relationship, correct? Yes. On redirect, the prosecutor asked Pete questions that were follow-ups to areas defense counsel had raised. Pete testified people had been making up things and putting out different stories that weren't true, saying that I'd never been shot at all. So Pete continued, I had to come out and say, yes, I was shot. I didn't just step on glass. I should have told the truth initially. I know that now. And I thought I was trying to protect people. I thought I was doing the right thing. I thought I was protecting myself, but in the long run, I wasn't. And the court talks about relevant evidence, what it means, and it has the case laws. You gotta see it's 40 some pages. We're not going through all of this. The court has discretion for the most part to determine what's relevant. I don't think it's anything else on here. So he also argued, and the second issue he argued was Peterson contends the trial courts reversibly erred in admitting evidence of Peterson's creative expression, specifically a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Cabral testified she and her partner stopped a vehicle that matched the description of a vehicle on a radio call they received. 4 people later identified as Peterson, Pete, Harris, and Smith were in the vehicle. An ambulance took Pete away, and Cabral and her partner arrested the other 3 and took them to Hollywood Station for further questioning. As the officers had found in the vehicle a handgun that was warm to the touch and in the slide lock position, when they got to the station, they tested Peterson, Harris, and Smith for gunshot residue. The prosecutors marked as exhibits 3 photographs taken at the station that depicted Peterson, Harris, and Smith. In a photo marked Exhibit 18, Harris and Smith, respectively. In a photo marked Exhibit 18, Peterson appears to be wearing a black shorts or swim trunks. He is shirtless and tattoos on his chest and arms are visible. In a photo marked as Exhibit 19, Harris appears to be wearing a black 2-piece swimsuit. Tattoos are visible on her arms and left thigh. In a photo marked as Exhibit 20, Smith appears to be wearing black pants and a long sleeve black top. At a sidebar, Peterson's counsel objected to the photograph, arguing it was irrelevant and would only sway the jury because it looks like he's got tattoos. The court replied the photos were to show who the people are that she, referring to Officer Cabral, took the swabs from. The court continued, I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? At the conclusion of the evidence, the court discussed the exhibits with counsel. When the court asked defense counsel if he had any objections to the admission into the evidence of exhibits 18, 19, or 20, he replied, no, Your Honor. In support of his claim, so they didn't want the pictures, okay? Saying it was creative expression. It felt like it was prejudicial. In any event, the record does not support Peterson's contention that Exhibit 18 injected racial bias into the proceedings. The prosecution did not offer the photograph as evidence of any alleged gang affiliation. There was no gang allegation in this case, and no one ever suggested that Peterson had any gang ties. The prosecution offered Exhibit 18, and the court admitted them into evidence solely to show the identity of the individual officers swabbed for gunshot residue at the police station. So there's that. Peterson asserts the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Peterson's chest. Defense witness Culberson testified he was Pete's stylist and friend. He sometimes was Pete's driver as well. From the questioning, it appears the defense called Culberson to ask him if Pete or Harris had a gun in their luggage. On direct examination, defense counsel also asked Culberson if he'd ever seen Tory with the gun. Culberson replied no. Counsel asked if Peterson ran around with guns. Culberson answered no. So that's EJ, I believe. On cross-examination, the prosecutor asked him a series of questions about whether he'd ever seen Harris with the gun and whether he'd seen Pete with the gun at any time of the day or night. He did not ask Culberson if he had ever seen Peterson with the gun. On redirect, defense counsel then asked Culberson if he'd ever seen Peterson with the gun, if he'd ever seen Peterson have a bag that has some weapon with it, and whether he'd ever seen Peterson discuss anything about firearms. Culberson answered no to those questions. I'm not going to go into that. Thank you so much, Gwen Brownlee, for the super sticker. You said he can't hold it. He can't hold liquor. Nah, he picked the wrong thing to do in any state. Jay said he will for sure be deported and won't ever be able to enter the U.S., at least not for another. Well, it could be negotiated. Maybe he get a good lawyer to negotiate that. He picked the worst state to act a fool, and these enhancements changed everything. I don't think Rick James got that many charges. He looked like the judge felt like it was a wash based on the mitigating, so he stuck to the guidelines almost, it looks like, and he just did it midway, like he did it in the middle. 4 people in the car and the defendant doesn't testify is a bad look, bro. Well, you'll see in a minute why he's claiming he didn't testify. He's blaming the prosecution for not testifying. Be very interested to see why. Hold on. Here we go. It's the next one. See, you did a great segue. The trial court did not impermissibly chill Peterson's right to testify. And as Peterson did not testify, he cannot raise this issue on appeal. That's the topic. Peterson asserts, quote, the jury did not hear Peterson's account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross-examination. Peterson mischaracterizes the record. Midway through the defense case, the prosecutor told the court he was asking to inquire about prior acts of violence if Peterson testified to rebut the character evidence put on by the defense. So when you open up the door for someone's character, then you basically, when you decide you want to talk about character, you open up the door for the other side to say about your lack of character or the negative aspects of your character. So you have to be careful what you present when you're in court. You have to be very methodical with what you use and what type of questioning you use. The court replied, well, I think the state of the evidence as it is now, I would not allow that. Of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say. But at this point, I will exclude that. So at this point, when the prosecution was asking about, the court said, listen, at this point, I'm more inclined not to inquire about prior acts of violence. The prosecutor listed a number of items with which he proposed to impeach Peterson, including social media posts, rap lyrics, Instagram posts, a 2019 Miami incident, a 2022 incident with August Alsina, an incident with Love and Hip Hop star Prince at a Florida's nightclub, and more. So the prosecution was trying to hit him with the business, like this is how he is. This is his MO. So according to the footnote, it says Alsina is a singer and songwriter. The prosecution alleged Peterson, wearing heavy rings on his fingers, had punched Alsina without warning on September 17, 2022 in Chicago, knocking him to the ground and bloodying him. The court stated some of this would be admissible, those portions that pertain to this case. Some wouldn't. The court continued, the best I can tell you at this point is if your client testifies, I have to take it on a case-by-case basis. But essentially, anything pertaining to this case obviously is fair game. If it pertains to some other incident, maybe it is, maybe it isn't. It depends. So the court left it up in the air. Listen, you have them testify. I may or may not allow certain information to come in, but you got to see. We got to see once he hits the stand. After the defense had called 7 witnesses, the following exchange took place. The court said, so Mr. McDeason, You've advised me that your client has elected not to testify. Mr. Magdesian said, that is correct, Your Honor. The court said, so Mr. Peterson, you know you have the absolute right to testify if you choose. You have the absolute right not to testify if that's your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. Do you understand what I told you so far? Yes, Your Honor. Have you had a chance to discuss the decision with your attorney? I have, Your Honor. And based on your discussion, is it your choice at this point not to testify? I will not testify. Neither Peterson nor his counsel ever told the court that Peterson wished to testify, but was deterred by the prospect of impeachment by the prosecution. So they said the court ain't had nothing to do with that. You ain't testified because you ain't want to testify. That's that. We asked you, you said no. That's on you. You said it's wild to see so many people still didn't look at the facts. People really in here don't want to know the truth. They don't. I wish this appeal decision happened last week. It would come out the day Trump was mentioned in the Epstein email. I talked about that actually. He caught. Is that in this document? Child, you know I'm skipping over stuff. Yeah, we went over a couple of those emails today, but more came out. We know it's an issue over there and at the White House because they did a press conference on it too. So yeah, them Epstein files is filing today. The mention of Peterson's criminal case in Florida was not prejudicial. Somebody mentioned that. So I'm going to talk about that as well because somebody mentioned that in the chat about this gun charge. Peterson asserts inculpatory statements, which were inculpatory as to the shooter's identity, were improperly introduced in spite of their factual falsity. Peterson apparently is referring to Pete's testimony that shortly after the shooting, when she and the others heard police sirens and Peterson offered her and Harris $1 million, Peterson said, I can't go to jail. I already got caught with a gun before. Don't tell on me. A few questions later, the prosecutor asked Pete, what's he saying exactly? Pete replied, I'll give y'all $1 million if you don't say anything. I can't go to jail no more. I'm already on probation. So that's where the probation came from. In the defense case, Peterson's counsel recalled the lead detective Ryan Stogner. Counsel questioned Stogner about his interview of Pete after the shooting. Counsel asked if Pete had told him that, quote, Peterson stated, please don't say anything because I'm on probation. Stogner began to answer. It was something to that. When the prosecutor objected, the court overruled the objection. This exchange followed. So this is how the testimony went. Question, sir, did you do any investigation afterwards to find if my client was on probation at the time of this case was happening on July 2020? Yes. Was my client on probation, sir? No. Not to the best of my recollection, sir. No. After defense counsel asked Stogner about the probation, the prosecutor began to ask a question about it. Defense counsel objected. At sidebar, the prosecutor told the court Mr. Lanez was actually on a Florida-Miami probationary term that started in 2017. She added that even if that were not the case, defense counsel was accusing the victim of lying about what Peterson had said. Defense counsel stated Peterson got arrested in the Miami case but was never charged. Outside the jury's presence, the court and counsel discussed the matter at some length. The prosecutor told the court the defendant was ordered diversion for a gun possession in 2017. He released an Instagram live video where he talks about going to his probation officer. After more discussion, the court stated, I will allow you to inquire that there was an incident in 2017. He was placed on court diversion. Don't mention what the arrest was for, and we'll leave it at that. Later, defense counsel and the prosecutor stipulated to advise the jury that Peterson was ordered a grant of diversion for a criminal case in 2017, and that diversion was terminated in April of 2017. The court told the jury the stipulation meant that is a fact that's not in dispute in this case, and they were to accept that as conclusively proven. So they agreed on both sides that he was in a diversion program. Apparently, as someone mentioned, he did some video where he said he was going to his probation officer. When you are in a diversion program, you do have to report. Now, you do have to report. And then typically, how it goes, again, I don't know the facts of his case, but typically it gets dismissed if you satisfactorily complete whatever they ask you to complete. So you don't have a record. If they look you up, only people should be able to see you have a record are obviously the FBI and the courts, because they will use it against you if you get, in some incidents, they'll use it against you if you get in trouble later on. So they can utilize it for certain instances, but like if you're regular, like your regular smeglo employer, they shouldn't be able to look it up and pull it and see your background. Both counsel also agreed to a special jury instruction about diversion. In accordance with the agreement, the court instructed the jury about the nature of diversion. The instruction stated, quote, diversion and excuse me, scratch that. Let me start over. Diversion and probation are not the same. You are not to speculate about the circumstances of Mr. Peterson's grant of diversion in 2017. It was terminated in 2017, and you are not to conclude from this evidence that Mr. Peterson has a bad character or that he's disposed to commit crimes. Thus, after the prosecution asked Pete about Peterson's statement, defense counsel raised the issue of probation with the detective in an effort to show Pete lied to the police. Pete's testimony that Peterson said he'd been caught with the gun before was not false. In any event, Peterson's counsel reached an agreement with the prosecution to present a stipulation with the true facts to the jury and for the court to instruct the jury on what diversion means. The record does not support Peterson's claim of error on this point. So that point didn't stick. Now, the biggest thing, one of the biggest things that happened was Kelsey Harris. She got on the stand. She had her husband. He was like nearby. She gets on the stand and she says, first of all, it was a whole lot of dead time, I guess, in between because she didn't want to testify. She was pleading the fifth. They gave her immunity, all of the things. She gets on the stand. I don't remember. I don't recall. I don't know what I told the police because I lied to the police. I don't know. I don't recall. Huh? The only thing she answered, they was like, did you shoot her? Prosecution asked her, are you the one that shot her then? She's like, no. So they played a video of her talking to the police. And she was nothing like she was on the stand. You on the stand, it felt like she just didn't want to be there. She knew the publicity was going to be negative, like almost she knew how the Tory fans were going to be. And so she was trying her best not to really testify against him. I'm not saying she was trying to just help him, but she was trying to not testify against him. So they played a audio that was recorded when some months later she came to the prosecutor's office. Apparently they had been trying to reach her before or something and they couldn't. She goes to the prosecutor's office. They record this video. She has an attorney allegedly that's on the phone. Her husband is there. I believe there was some type of legal representation there, but she was covered. And she was talking just like how you and I are talking. Yeah, I pulled out the text showing it. I couldn't believe he asked me that. He said he was going to help me start a business. I needed to talk to him. You know, he needed to talk to his lawyer. His lawyer told me that's the way we got to do it. I mean, she was just talking like you and I are talking. She was not, there was no distress. There was nothing. Nothing. And so when that got played, that's the moment I was like, he's going to jail. To me, that was the moment for me. All the other stuff, I was, it still was a little. I wasn't really playing Sean Kelly's testimony because he was kind of back and forth a little bit. But when that happened and how calm she was and just the environment, she had no reason to really, like, in my opinion, just she was acting for real on that stand. And that's what it looked like. And the jury it was just hard to watch. It was so hard. It seems unnecessarily taking up time. It was just a lot with that. But when they played it, you get a whole clear timeline of everything that happened, how it happened. I mean, it was no hesitations. The story was just told just like how I'm telling you. It was just so I was asked, I remember on the elevator, I was asked, do you think that, oh, I don't think this even this wasn't good for the prosecution. I don't think this helped the prosecution at all. I was like, girl, this is horrible for Tory. What are you talking about? You think so? I do. And that's how I'm going to report it. I think it's horrible. And that was the conversation about that. I mean, to me, it was believable. It was. Why she make a diss track? So she made a diss track because apparently, was it one? I think, did they play it? I think they played it too during the trial. This child was interesting. She did play the diss track because I forgot why she testified to, I think, why she did it. I don't remember, child. That wasn't a whole complete fool 504. Oh, she switched up for real. Kelsey's police video is the best retelling the story. That was how I looked at it. But when I seen some of the Tory fans that were like, oh, the prosecution messed up by playing that, I don't think that helps at all. I was like, what? That's how I knew that it didn't matter what these people heard. They were going to say whatever when it came to Tory. All I have to say is y'all should have just went to what does it take? What is considered wrongful conviction? Find out different things as to what you have to prove and how you got to prove it. Just relitigating the same stuff over and over again to say it wasn't sufficient evidence to find you guilty is just, it just wasn't accurate to me. Thank you, T. Collins, for the super chat. You said I'm behind, but thanks for the facts. Thank you. So when you catch up, you can get your thank you when you catch up. Jay said that this track was trash, but she did it because Megan wouldn't come out and exonerate her. Yeah, that's it. That's it, Jay. Thank you. See, this was so long ago. Y'all know I'm old. That diss track was trash, but she did it because Megan wouldn't come out and exonerate her or have her back. That's what she did testify to. She said that she felt like people were coming for her saying she did it. Meg knew the truth. And what is interesting, and I would really, now this is one missing piece that I have not got the answer to, and it has somewhat nothing to do with the criminal aspect, but maybe it does. But I would want to really get into it if I were into this case. Is after all of this happened, Meg cut Kelsey off. So I could totally see if it was the opposite, where Meg was messing with Kelsey first and then Kelsey started sleeping with him. I could see her doing that, but I never understood why Meg totally cut her out. So apparently, according to Kelsey, she moved from Texas. She sublet out her apartment or wherever she was staying at. She subleased it out. She went and she traveled with Meg as her assistant. So Meg had something in New York where they had an Airbnb, and they were staying at an Airbnb in Florida. And so when all of this stuff happened, when they were in California, I think they might have had an Airbnb there or whatnot. They were staying together because she was basically she uprooted her life and was traveling with her. Once Meg was in the hospital and she left, she testified, and I'm paraphrasing this, but she was just advised by one of Meg's people we gonna get you a plane ticket so you can take your behind back to, back to Texas. And she never really knew why. Like she said that, like she never knew why. She just was like, well, and I guess Meg did like give her money for the month or something. And she's like, yeah, I had subleased out my place already and da 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 da. And I believe Meg was like, either she gave her money or was gonna get her another place to stay for a certain amount of time so she can get it together. But she didn't really mess with her no more after this. So I don't know what that's about, but that's very suspicious to me. I will say that. I thought that was like interesting. Oh, that's the room. I never heard that. Meg cut her off the same night. Come guys, y'all know she pulled that. You know what? No. Here we go. You just gonna ignore all the evidence, huh? It's just some people just gonna ignore all the evidence. The same reason why she go behind her back and sleep with multiple dudes because it was she's low down and try. Well, dang. Well, dang. Okay. And Dree said Kelsey asked them to buy that ticket. When they bought it, Kelsey was mad because she said they bought it too fast. Um, I don't know. Yeah, she said she didn't have money or something, and they did. They put her on that plane immediately. Now that's one thing they did do was put on that plane immediately. I remember that. I ain't really getting to that portion too much because to me that was a unresolved portion of like the testimony and all the stuff that we saw was why did you die? Like I want to ask Meg, like, girl, if you free, I know you about to testify. Why did you tell Kelsey to kick rocks? I just want to know. Why did you feel like was it because she was pro Tory? She seemed like you seemed like you, but I mean, I don't even think she had time for that the way she sent you back home. I don't know, but that's a very interesting maybe she just wanted to start over and she ain't want none of them in her life. She was like, I want a clean slate. I want all this to be behind me. And that was it. Um, let me see. One thing about Meg, she cuts people off with the quickness and moves on to the next. I mean, that is the gift. I got the gift of goodbye too, but boy, oh boy, I was like, what is this something else I'm missing here? So y'all blame Rock Nation for everything. So Zingin said Rock Nation got rid of her fast. Isn't like her man or something affiliated with Rock Nation? Like Kelsey ended up marrying somebody that was somehow connected, or am I getting that wrong? Yeah, I'm sure her father, because there's people in the chat doing that right now. Her father and I with her fuel the conspiracy theory. Yeah, but and then how do y'all? But they're still just gonna act like the evidence not here. See, I don't get those type of people. I don't get those type of people that's just you're gonna stick to this, even though if, like I said before, and I said that as soon as the guilty verdict was in, if you're going to say new trial, the media is not going to help you. These people in the chat gassing you up ain't going to help you. These people lying to you. They don't care about you because they just lying to you. They're not going to help you. You need to do what you're supposed to do, which is get an investigator, find some ring cameras, find some evidence that just was not collected, find maybe somebody was nosy with a phone, find something. You had the money to like for real investigate this case. I think maybe it was underestimated. Maybe that was why. But that is how you try to get information to try to help you with a new trial. You don't just say, I don't like the way they said it. or I don't like the way the jury went. I mean, typically somebody's not gonna like. One side ain't gonna like. One side's gonna think that their side is the right side. Off topic, but have you seen All's Fair on Hulu? If so, what did you think? What do you think about Kim K saying Chat GPT made her feel the California part? Okay, so you get me. I just watched All's Fair. So I'm gonna be honest with you. I watched the first 10 minutes and I cut it off. I was like, why is this like goofy to me? It seemed goofy, all right, in the first 10 minutes. But then I was washing dishes or cooking or doing something. So I cut it back on. I say, I got to give it another shot because Tiana Taylor is in it. And I was like, I want to want to give it another shot. And so I turned it back on. And then towards I'ma say, if you could make it like 20-25 minutes, it start cooking a little bit. It still got a little goofiness to it, but it does start cooking. Like it's better as you get into it. My issue is the same issue I have with a lot of Tyler Perry movies. If you don't catch my attention in them first few minutes, I move on because I really don't have time to watch anything for real. So when I watch it and it's usually just some wind down time, I expect it to be great. All right. So I did watch those 3 episodes and I think it's a decent show. Think it's okay. You just have to like for real watch for it to pick up its steam and see where it's going. Again, it's a law show for those of you that don't know. I don't know nothing about Chat GPT making. What do you mean Chat GPT made her feel like she's used Chat GPT to study? I know that's not it. I don't know that portion of it. You have to let me know what you're talking about, and I'll answer that to the best of my ability. Thank you for the super chat. Sunshine Blazing says sometimes you have to clean shop. Let it go. I'm sure her PR person told her we better. Yeah, that's what I said. It could have just been that she was just ready to sometimes you have to clean out. You can't be cool with everybody. When you get to different levels, sometimes people will say you're bougie, people will talk about you, but it's not always good to take everybody with you. And that's a part of your life that maybe she just didn't want around her anymore, which, it's up to her. She probably wanted to move on. She probably did talk to people that were in her tribe or her label or whatever she was doing, and they may have done it. I don't know. I just thought it was interesting because I think the testimony, as someone said, it was part of what was sparking. Oh, she ain't want to talk to her no more because she did A, B, C, D, and E, and this is an admission. But y'all gonna just forget everything else that you see, the text message, the audio, all this stuff from this guy. We just gonna ignore that. But we're gonna create a scenario about something we don't really know. Create something out of thin air and say this is proof that she did it. Like that. I don't get that logic, but hey. She said, "Nah, I think Megan ain't ish, but she definitely was harmed that night. She has a long history of being a terrible friend. So Rock Nation advised cut off. It was like music to her ears. Oh wow. Okay. Oh, she used it to study. Well, that's on her. Why would you use ChatGPT to study? I know you guys are playing with me right now. ChatGPT to study, like ChatGPT that gets a lot of its information from what we input. That ChatGPT. Oh my god. I can't. Blue Diamond said, "What I will never understand is prior to legal charges brought on by the state, he was apologetic, but afterwards, she's the liar and a mega villain." Well, if Kim admitted that, why was she? Oh, child. So Peterson contends the trial court reversibly erred in permitting the prosecution to play for the jury its recorded interview with Kelsey. So that was another one. Um, And they basically used it, she said, to refresh the recollection because she was saying she don't remember. I don't recall. I don't know. I don't recall. Then he says the next issue is the trial court did not abuse its discretion in admitting evidence regarding an Instagram post. Peterson contends the trial court erred in admitting an allegedly inculpatory Instagram post, which was disclosed to the defense in an untimely fashion, amounted to inadmissible hearsay, was highly prejudicial, thereby resulting in a manifest injustice. We do not agree. So after the juries were selected, the court excused them so it could discuss various issues with counsel before opening statements, which was set to begin on Monday. During that discussion, the prosecutors told the trial court and defense counsel that they'd just been made aware of a September 2020 Instagram post by the defendant in which he said he made a comment posted by someone else that Harris shot Pete was not true. So you guys may recall this. The prosecutor gave that information on a CD to defense counsel. So on the Shade Room, shout out to the Shade Room, someone said it was Kelsey Harris who shot Meg and Pete. Well, someone from Tory's Instagram page said not true. We gonna ignore that too, though. I'm gonna repeat that. Someone on the Shade Room said that Kelsey is the one that shot Meg. And someone from Tory's Instagram page, verified page, said not true. The following Tuesday, the prosecution filed a motion to admit the defendant's statement on Instagram. The prosecution attached to its motion a photograph of a post by Lil Jew Made the Beat. Lil Jew Made the Beat, made black and white, and made the trial. That said, quote, this goofy A ninja say he ain't shoot her, and they literally have matched the bullets from his gun to the ones in her foot, end quote. Below is the statement, quote, liked by Frost D. Cupcake and 281,393 others. Next, by the Shade Room, hashtag Megan Thee Stallion's producer alleges that authorities have matched the bullets from hashtag Tory Lanez guns to the ones found in her foot. See earlier post. Under that view was 13,727 comments. Next, Spliff K says, quote, people saying Kelsey shot her, crying emoji. Finally, a post by, quote, Tory Lanez at Spliff K says, quote, that's not true, end quote. The date on the post was September 25th, 2020. So then there was a bunch of testimony. I'm going to save you all of this, where they had someone get on there and say they were some type of detective and they were familiar with social media and verified social media accounts, and that connecting that it really did come from his account and blah, blah, blah. Of course, on cross-examination, it was, there are a lot of celebrities who don't control their accounts. Someone else has access to their accounts. And this detective obviously doesn't know who's behind the keyboard because you just don't know who actually typed it and who didn't type it. So that was pretty much what their argument was. But they're saying that this should have not been admitted. Okay. Said it was hearsay, and also because they told them about it late and they submitted it late. So the court pretty much said, so there was a declaration filed by Josh Ferris with his motion. He declared he was the manager of Peterson's Instagram account, and he was the person who replied, that's not true. Why would his manager just say that, though? Ferris declared, I never consulted with Mr. Daystar Peterson in posting that comment on September 25th, 2020, and ruling on Peterson's new trial motion. The trial court stated the Ferris declaration was not newly discovered evidence. Didn't I just tell y'all about newly discovered evidence is not stuff that you already know, things you already talked about, things that were given to you, things that you gave to someone else, things that were already produced, information in the trial. That is not newly discovered evidence, which is what is needed when you try to do these type of motions for a new trial. Anyways, the court said, continued, I think that's something that could have been discovered through reasonable means, like could have been knew that. So then the court says, finally, any error in admitting the Instagram post was harmless. So even if it was an error, it would be harmless. As the trial court noted, the Instagram post was an extremely minor issue in the case. The case turned on Pete's testimony, Peterson's admissions to Harris when he called her from jail, and other similar evidence. Detective Ed Hart testified he was not saying that Peterson had posted the statement. That's not true. And he admitted he had no knowledge of who controlled Peterson's Instagram account. So that failed. So then the trial court about instructing on the enhancement. We're going to skip that. Let me see. Any ambiguity in Cal Crim number 3160 is harmless in this case. On the allegations that in committing the offense in counts 1 and 3, Peterson personally inflicted great bodily injury on Pete, the trial court instructed the jury with the jury instruction 3160. The instruction states, quote, great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Peterson cites a bench note following the instruction that cautions courts this sentence of the great bodily injury definition could result in error if the prosecution improperly argues great bodily injury may be shown by greater than minor injury alone. And then they cite a case. Any ambiguity in this definition is harmless in this case because substantial evidence, y'all listening? Listening. Substantial evidence established beyond a reasonable doubt that the injuries Peterson inflicted on Pete were more than moderate harm. Indeed, they are more properly characterized as significant or substantial harm. Pete had surgery to remove bullet fragments in both feet. She had a lot of pain and couldn't walk for a while. Pete had physical therapy for a few months. The orthopedic surgeon who operated on Pete's feet testified at trial, and the jury saw x-rays and a report of the operation. The surgeon told the jury Pete was placed under general anesthesia for the surgery. The surgeon described in detail the steps a team of 3 surgeons took to remove questionable tissue and the metal fragments, flush the areas, and close the wounds with sutures. Pete was admitted to the hospital after the surgery. This testimony was more than sufficient to support the jury's finding that Peterson personally inflicted great bodily injury to Pete. So it still amazes me the people that were sitting in there that are saying she stepped on glass because that's what she said before. And already admitted she lied about stepping on glass when you heard a whole surgeon from the hospital. They were even trying to background the surgeon and find out. I don't know. Maybe he was a surgeon for Rock Nation too. I don't know what. I was like, what are these people talking about? They were talking about the surgeon and connecting the surgeon and whether his credentials. I mean, it was just going on and on and on. The surgeon testified, I took these bullets out. What I'm in the trauma unit. This isn't the first fragments I've taken out. Said some of the pieces are still in her foot because they couldn't even take them out. She only had some of them taken out because they couldn't take all of them out. A whole surgeons. Okay. A whole surgeon. All right. So they're saying that was sufficient. Then they talk about the prosecutor's statements. They had an issue with that. Um, so the record does another issue was the record, the court ruled, the Court of Appeals, the record does not support Peterson's contention that prosecutional misconduct interfered with his right to conflict-free counsel. So this is the Sean Holly, who is probably my favorite attorney on this here earth. This is about Sean Holly. For those of you that don't know, she's actually one of the executive producers on Reasonable Doubt. Y'all got to go watch that on Hulu. Now that I truly recommend. Okay. But anyway, she was representing Tory Lanez in the beginning, and it was some instances that he always had, from my understanding, Magdesian, and he has Sean Holly. Sean Holly has represented him in other issues and that he's had, and she represents a lot of celebrities as well. But anyways, Sean Holly was unable to try this case, which means the other person, Magdesian, who was on the case already, from my understanding, is the one that tried the case. Now, what I will say is I did not feel it was good to have a male cross-examine her. I think it came across pretty hard. And I seen there were a few women that were in the hallway that said they worked for this man's firm, but it was him at the table and there was another male. And the women were in the hallway. I don't know how new they were. I don't know if they said they worked for the law firm. I don't know if they were actual attorneys, if they were assistants, but I felt like at least, and I get it, Meg the Stallion would have been the key witness that needed the best, most seasoned person to be the one to do the cross. But I think it comes off a little harsh sometimes. It matters who you have do cross and direct on certain people. But anyway, yeah, that show was good, ain't it? Is it? Kalanja, is it really crazy? I don't know. That's the type of stuff that I hear on this here internet. They blame them for everything. Okay. So Peterson retained, y'all listen to this. This is about Sean. I haven't read this yet, but I know he was arguing before that he felt like he tried to blame Sean Holly in a sense, and Sean Holly had to release information. She said she didn't think it was a good idea, but she had to obviously release it to protect herself as well. And we learned in that information that one of the suggestions was she didn't think that the Kelsey defense was a good way to go. But all that was released because I think it may have been it might have been biased. One of those attorneys were trying to somewhat blame her and her abruptly being removed. Now they didn't have the female to be able to direct or cross-examine Meg to say felt like it affected his trial. Anyway, let's see what this argument is. Peterson retained Sean Chapman Holly to represent him in this case. Holly represented Peterson through the preliminary hearing as well as the extensive pre-trial proceedings. According to Holly, with trial expected to begin in late November and December of 2022, Peterson wanted to, quote, to add another lawyer to the team, George Magdesian. In a September 6, 2022 email, Holly explained to Brian Gott, who appears to have been Peterson's business manager, quote, Tory has known him for a long time and trusts him, end quote. Holly was engaged in an arbitration out of state that began in May of 2022. It did not conclude until December 16, 2022, nearly 2 weeks after trial commenced. In a letter dated January 10th, 2023 to the trial court, Holly referred to this other engagement and explained, quote, Mr. Peterson understood and agreed that George Magdesian would represent him at trial and that I would not, end quote. An email Peterson attached to one of his pleadings in connection with this motion for a new trial reflects a second reason Holly did not represent Peterson at trial. In the email, dated November 21st, 2022, to Peterson with a copy to Desian. I know I'm messing your name up. Sorry, sir. Holly stated she was not comfortable advancing a defense theory that it was Kelsey Harris and not Peterson who shot Pete. In Holly's view, it was not a viable strategy. Holly recommended that Peterson discuss with Magdisian his willingness and ability to move forward with that defense. The record again, an email Peterson filed in the trial court reflects a third issue. On December 18, 2022, Holly emailed Peterson to let him know that she was going to file a motion to withdraw as one of his attorneys of record. Holly stated evidence had been, quote, elicited during Harris's testimony that Holly, quote, was somehow involved in facilitating an arrangement between Peterson and Harris whereby Peterson would finance Harris's business or something like that in order to curry favor with her, thereby aligning your and her interests as far as the case was concerned. So, again, another reason she was like, I got to get up out of here. There was testimony where it was alleged that they said that somehow Sean Holly's name came in like she was going to be some facilitator of this business in order for him not to testify. Of course, she's a whole lawyer. Like that's not good. Holly continued, you and I both know that this never happened. Holly added she did not know whether Peterson actually made such a statement to Harris or whether Harris made this up herself. Holly stated, all I do know is that this did not happen, nor would it ever happen. Holly explained, in any event, the fact that these false allegations have been made about me and that they are now evidence in the case makes it a conflict as an ethical legal matter for me to continue to represent you, and as a result, I am obligated to withdraw as your attorney. Without any citation to the record, Peterson asserts, despite prosecutors' plain acknowledgement that Holly was not involved in the alleged bribery of Harris months earlier, prosecutors opted to wait until mid-trial to raise the exact same allegations, relying on nothing more than Harris's same inconsistent statement dating back to September 2022. Peterson claims these allegations left Holly with no choice but to disengage fully lest her presence harm her client. Peterson's wholesale failure to support any of these assertions with citations to the record is telling. The letter and emails Peterson himself attached to his new trial motion show the reason Holly did not try the case and ultimately withdrew was 1, she was engaged in a lengthy 7-month arbitration. 2, she was not comfortable with the defense blaming Harris for the shooting. And 3, after Harris's statement were introduced at trial, she concluded she had a conflict. Nothing in the record supports Peterson's allegation that prosecutors opted to lull Holly into a false sense of security by deceptively assuring her they did not believe her to be involved, end quote. So the court wasn't happy with this. With the whole Sean Holly one, they wasn't very happy with that one. Is this the last allegation? The trial court did not err in imposing the midterm. So basically they gave him a term in the middle of the sentencing guidelines. And then they said, as we find no ineffective assistance of counsel or prejudicial trial court error, we also find no cumulative error. We affirm Daystar Peterson's conviction. This is not to be published in the official report. Nothing in here that we need to be precedent. So there is that. That is the full 45-page opinion of the Court of Appeals. I thought Holly said she had another trial calendar conflict. She had a well, essentially that's what it is. She was in a facilitation. Realistically, what would have been a good defense? He should have just tried to get a good plea deal. Well, if he would have stopped talking, I mean, some of this was some talking. I think that it would have went a different way. I don't think doing a video, I don't think that was helpful. I don't think doing lives. There were some live Instagram videos I saw. I think that they played during trial. I just think he helped sabotage his own defense. If he, I mean, were there places I could see where you could poke holes? Yeah, I mean, Sean Kelly wasn't the straightforward with his testimony. It could kind of, waver a little bit. But do I think that his own words from text messages and voicemails and all of that, voice recordings did help him? No, it didn't help him. It hurt him. It did. But I don't have all the facts. I don't know what direction Sean Holly thought they should go in. I don't know, but she didn't like the Kelsey defense. She wasn't going for that. So when that music video dropped, I was shocked. You and a whole lot of people. So anyway, that is, I get all my super chats. Yes, thank you guys so much. We reached our goal. Thank y'all. I missed the celebration. I was reading. So that is the Tory Lanez. As you guys know, next week on Monday, it was Megan Pete versus Milagro Grams. And that is about I think it's defamation, and it was something with a deep fake video that I think she just liked or something like that. But yeah, it's been a lot in that case, of which there were deleted text messages, there were sanctions because of it. There's an adverse inference instruction that's going to go into the jury because of it. There were depositions where Tory Lanez apparently and allegedly acted like a fool. They had to compel a lot of the depositions. I know Academics was a part of one of the depositions, and he actually played it. It became content. He played it. I seen it on X. So yeah, it starts on Monday where they will have jury instructions. Yeah, it was lines after line. I don't know if it was thousands, but it was some between Tory and his father. Let me look up this case with Milagro and see if something happened today, because they did have a calendar conference. Let's see. I might have to come back in the membership and go back and talk about some of these emails. I have to look at them. I didn't see, aside from the first three that gave us, a little bit of taste of what was to come, I didn't see anything else. I went on as soon as I found out about the Tory. I am going to link some of my Tory videos. Maybe I'll do that at the end of this one, so you can see some of the commentary that I did during the trial. Well, you would have definitely thought that we were at different trials, because I was like, what are you guys looking at? Let's see. Help. Something was filed today. Well, something happened today, November 12th. Pre-trial conference. Their pre-trial conference was 3 hours long regarding defendant's non-media status. Hold on. Pre-trial memo. Hold on. Let's see what this is. Let's be nosy. So they're saying she's the non-media status. What are they referring to? Hold on. Let's see what this is. This was filed today in the Megan Pete versus Milagro Elizabeth Cooper memorandum of law regarding defendant's non-media status. The court has already concluded that defendant is not a media defendant. Based on plaintiff's well-pleaded allegations, the court concludes she, defendant, does not qualify as a media defendant. In the motion to dismiss the amended complaint, defendant argued that she was a media defendant and was therefore entitled to pre-suit notice as a jurisdictional prerequisite to being sued. The court rejected that argument, finding that she did not advance sufficient facts to prove her status as a media defendant. Because the media defendant issue relates to the court's jurisdiction, defendant could have introduced evidence to establish that status, but she does not argue the appendices serve the purposes. If the court had found her to be a media defendant, the court would have lacked jurisdiction to hear the case. Nothing has changed since the court's order on the defendant's motion to dismiss. Defendant has not proffered or pre-admitted any evidence suggesting that she is a journalist and should be treated as such, nor can she. So there's certain protections under journalist. And so I guess she was trying to use the journalistic defense. Any contentions the defendant raises now at this late stage about being media defendant should be rejected. Even if the court were to search the record today, the facts still show defendant fails to qualify as a media defendant. To determine whether a defendant qualifies as a media defendant, courts look at the defendant's function. As Judge King stated, the function of the media is to inform and to initiate uninhibited, robust, and wide open debate on public issues. In Ortega, the court found that a public relations firm was not a media defendant because it, quote, does not impartially disseminate information or issue unsolicited, disinterested, and neutral commentary as to matters of public interest or to editorialize as to matters of public interest without being commissioned to do so by its clients. In the same way, defendant is not a media defendant and has said so herself. So then they say, okay, so she says she's not a media person herself. They done pulled one of her live streams from October 29, 2024, where she says everything is not meant to be a news report. I did not tell anybody I was a reporter. Miss Cooper, I ain't never told you I went to school for journalism. What effing article did I write that I posted and said, y'all read this? What the F are y'all talking about? I don't think I'm anything, but I know I'm the person that gets under y'all skin. You don't need to be a journalist to see something and give an opinion about it. So my whole thing is, if I'm not trying to be a journalist and you know I'm not, what the F you mad about? Because I shouldn't be regarded as a news source any damn way. Can't use this defense. Defendant also stated during deposition, I do not know the ethics of journalism. I don't have a background in that and I am not aware. Defendant's function has never been to impartially disseminate information or inform on matters of public interest. Rather, defendant's spread of misinformation, charge commentary on matters that lack a connection with the public interest, such as Miss Pete's alleged mental status or family background, and evidence of defendant being commissioned by the Petersons to publish her statements, all underscore defendant's non-media status. So they saying they got evidence that she was commissioned by the Petersons to publish these statements. Ahead of trial, the court should conclusively hold that defendant is indeed a non-media defendant. So apparently they were probably told to write whatever objection they had, because maybe she's going to be trying to use that defense that she's media, and so she should be afforded the same defenses as media. Because as media, before you get sued, I think they're supposed to give you a pre-suit notice. Like they're supposed to give you notice before they file a suit. And if they don't, you can ask for it to be dismissed. So they're supposed to inform you first. So yeah, there's that. You said station head strikes again. Man. Elite Leo said Milagro, Tory, academics, they all talk too much. So the way I'd be like, they wanted the case moved out of Florida. They probably would have wanted. Well, I think they're saying they were trying to just get it dismissed because they're saying you don't have the court doesn't have jurisdiction to hear the case because they didn't follow the protocols as a journalist or a media outlet. So they were trying to use that when I think it was Unite the People, probably the motion to dismiss that they filed. But honestly, I could see why they would want it dismissed from Florida because Florida has different laws. This law, from my understanding, related to this deep fake. So what is alleged? Somebody did some deep fake type adult interaction video of Meg the Stallion on Twitter. Allegedly, it was from the video I saw, to be honest, I thought Milagro was saying, I don't believe the video is true and all of that. But apparently, they have a provision that says if you promote it, then you're a part of it. So if you go and you tell people, go watch it, tell me what you think, share it, comment, whatever, that's considered promotion under this can be considered promotion under this statute. So this is what is alleged that was done. And again, I did see a video of her saying she didn't believe that it was real. She did talk about it. So she didn't, from that sense, she wasn't saying it was really it, but it was like, you know how you just throw your rock and hide your hand. I think that's how the court was looking at it. Like you kind of tell people about it. You brought recognition to it, but then you got the video say, I didn't even believe it was real anyway. I mean, the mud could be fake to me. Like I did hear some audio with her saying that on I might have been YouTube, but you know how to curse. She does. She curse every other. She definitely does. That's why I said I wonder how people think. Like, if you know that your commentary might end up in a transcript and people may have to watch you and see your transcript, like the court is going to attach this transcript of your text messages and how you choose to conduct yourself in public on these platforms. Do they get embarrassed? Like when they know the court is saying this ninja and MFers and that stupid hoe and da da da. Like, do you feel embarrassed when you read that the court has read this, obviously, and put this in one of their opinions? I would be like appalled. Like the text message of Tory with the probably. I would be appalled. Like, what? But hey, some people don't care, I guess. I don't know. But that's how I look at everything. Like, this might end up in a pleading one day. She started saying she did not think it was real after commentators told her she could be liable. Oh, okay, Motivation Nation. Obviously, I don't. We followed each other on Instagram at one point. Like, again, I met her at the Tory trial, but and we communicated and I thought we were pretty cool. You know, we were cordial. Gonna say like give me your number, type thing. But we were like cordial, and that was pretty much it. So I wasn't a person that just listened to her commentary. If I seen her on Instagram and caught it every now and then, I would go ahead and watch it. But that was it. I never was on station head. Typically, people would send me links. I don't even have a station head. I don't even know how to really like. I'm like, the link won't let me on because it says I gotta sign up, and I'm one of those. So that's all I've really heard. But she was on, and I don't even know if it was her YouTube channel or if it was somebody who just took a clip of what she said and they were doing their own commentary on it. But I do remember hearing her say it probably isn't real. Like, I do remember that. I don't know the context. He said she knew what she was doing. She told her followers to go to her likes. Yeah, I know she told her followers to do something, and that's what was used in the court's opinion, that she promoted it, that it qualified for promotion. Elite Leo said, I heard some of the stuff she said, and she's ruthless. The stuff she said about Meg was just vile. Well, we'll see. It's about to go down. Some people thought it wasn't going to go. They thought it was going to settle, but I'm like, what you going to settle on? I don't know. I don't know what you would settle on at this point. I'm sure she would prefer it to be over. So yeah, but y'all, anyway, welcome to the replay. All you guys, I see new people coming in, but I'm getting off. So make sure you hit the like button, subscribe to the channel if you haven't done so already. Thank you all for helping me hit my goal. Again, we back at the, as soon as we think Tory is over, it's not over. So we'll see. Will he try to go further? Will he try to go to the Supreme Court? No one knows. But the appellate journey has ended for Tory Lanez as of now, unless something new happens. And that's that. Thank you all again for the commentary and the interaction. I appreciate you. I'm out. Talk to you later.